A big part, my lord, to make a mention, my lord. Lordship directed on 27/3/2024 to file an affidavit. But Lordship fixed it yesterday, my lord. Could not be listed because affidavit has not been filed. Lordship, remember, already I have remained for 6 years, my lord.
No matter relating to
Tomorrow, your lordship.
Yes,
to mention malord CRL mala 312/24 malord. Delivery it was malord BLPL malord. Thereafter your lordship direction converted into malord CRL.
Please give it.
Your lordship. CRL number 1333 of 2023. One IA not disposed, my lord.
Give it.
My lord, the petitioner is custody more than 8 years, specifically urgent but not listed.
May I be permitted to make a mention?
Bill 971 of 2019. I had mentioned this matter before Your Lordship a number of times. Your Lordship be kind enough to allow my prayer, but somehow the registry does not list the matter.
What is the matter?
This is a matter where the appellant was convicted on the finding that he had 16% DA. Your Lordship heard the matter in April 2023. I had pointed out that there is an arithmetical error, like 2 plus 2, and
No, it's for hearing.
It is in the list. It was in the list for orders and release of petitions, but it is a small matter.
No, whatever it may be, say if it is a hearing, whether the paper book has been prepared.
Everything.
Okay, they see that it is not listed. Yes.
It was in the list for orders, and Your Lordship had taken it up for hearing in April 2020.
No, I just.
Your Lordship heard me ask the State Council to reply. He wanted time thereafter.
All right. Paper book has been prepared, then it will.
Everything is ready.
Okay. Yes, Mr. Das, what do you say?
But if it is in the hearing list, it will not be there.
We'll see that. Why? Let it come first.
In the list,
Okay.
One matter, item matter earlier it was listed but delisted.
Please give it. Yes, Mr. Sarangi.
My lords, Your Lordship remembers this is criminal revision number 356 of 2023. That's a vigilance matter. I have never been heard because a false statement was made by the Vigilance Council that charge has been framed. Your Lordship urged it and called for a report. Thereafter, it has not come. Though it came because of the election dispute, it could not be taken up.
All right, it is noted down. It is noted. Yes.
Another prayer, my lords, BLAPL number 7387 of 23. Your Lordship called for a status report and fixed it to February 19th. Report is there.
Okay, we'll see that.
I am sending memos physically.
Yes.
Supplementary list of space 2 item 15. I have taken twice time and pray let it come 3 weeks after. He is not getting the certificate copies because trial is going on. So maybe 3 weeks after.
It's a juvenile matter.
Yes, juvenile matter.
No, trial is going on. You are facing difficulty in obtaining the certified copy of the deposition.
I have really asked him. Twice I have taken time. He is not able to send it.
No, the court can send it. Why are you worried about it? If you say I can call it that.
If the Lordship can do it, I will do it.
All right. They fill up the number. Mr. Das, where it is pending now? Because the rejection order shows that it's in criminal appeal. So, juvenile court, whether it is pending before that principal magistrate JJB or it has gone to the children's court for trial. And if so,
I'll verify and tell tomorrow. I'll verify and tell tomorrow.
I'm listing it. If you say it can be listed tomorrow, if you say. So just ascertain what is that case number, which court it is pending, and how many witnesses have been examined. Then I can call for it.
I'll verify.
Mr. Shakti Das, Grand Senior Advocate, 6 for an adjournment till tomorrow. Please this matter tomorrow, 10th of, yes. Yes.
Supplemental list, item number 11.
What is this matter, Mr. Sharma?
The case with the FIR was registered after thorough investigation. Police filed final form indicating therein that accused was not there at the spot, my lord. Then a protest petition was filed. Based on that, cognizance was taken. Your lordship, on 2nd of April 2024, directed appearance of both the parties. I'll ensure presence of my client, and state counsel is supposed to ensure the presence of the OP number 2.
Who is the appellant, Dr. Alok Ranjan?
Yes, my lord. He has come. He is present physically in the court.
Okay. No, in that college, who was
he was a reader. The allegation was made by the principal that he abused him in Filli language.
Okay.
So, your lordship,
both of them are in the same college now.
yes, sir.
Already
No,
retired.
Who has retired?
Gopal retired. He is continuing there as a reader.
So you are supposed to ensure the attendance of
the Gopal, my lord.
Oh,
We
yes.
already saw the notice also, and supervisor today morning also talked to the IAC. See, the Gopal, Mr. Gopal is suffering from fever or something, so he could not. They wanted to appear through BC, my lord. He is in Baripada court. He has gone to Baripada court to appear, and just now I also talked to the IAC. Can it be possible? So
Yes, yes.
when they will come, my lord, take up.
He is the person who has come, Mr. Sharma. He is the appellant, Dr.
Alok Ranjan Pradhan.
Call him, call him.
Yes, sir.
You take your seat. Both of you take your seat. Upon Udala College रे वर्तमान सर्विस अच्छी
Aja, sir.
कौन वर्तमान ऑब्जेक्ट
Reader in chemistry.
ଆଉ ଆପଣଙ୍କର ନାଁରେ ଯିଏ ଅଭିଯୋଗ କରିଛନ୍ତି ଗୋପାଳ ଚନ୍ଦ୍ର ବେହେରା ସେ ବର୍ତ୍ତମାନ ରିଟାୟାର୍ଡ କରିସାରିଲେଣି
ସେ ସାର୍ ଏଠୁ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଗ୍ରାଉଣ୍ଡରେ ଟ୍ରାନ୍ସଫର ହେଇସାରି ଭିଏନ୍ କଲେଜ ଯାଜପୁର ରୋଡ କୁ ଟ୍ରାନ୍ସଫର ହେଇଥିଲେ ସେଇଠି ସେ ରିଟାୟାର୍ଡ କରିଛନ୍ତି ଏଇ ମାସେ 2 ମାସ ହେଲା
ତ କଣ ଅସୁବିଧା ହେଲା କଣ ଆପଣ ଏଇଗୁଡା ଛୋଟ ଛୋଟ କଥାକୁ ନେଇକିନି ଆପଣ ଭିତରେ କଣ ପାଇଁ
ସାର୍ ମୋ ନାଁରେ ଗୋଟେ ମିଛ ଅଭିଯୋଗ ସେ କଲେ ଯେ ମୁଁ କଲେଜରୁ ପଳେଇ ଗଲା ପରେ 5:10 ରେ ସେ ଅଭିଯୋଗ ଗୋଟେ କଲେ ଯେ ମୁଁ ତାଙ୍କୁ ଗାଳି ଗୁଲଜ କଲି ବୋଲିକିରି ଏଇକି ଉଦଳା ଥାନାରେ ଅଭିଯୋଗ କଲେ ତାପରେ ପୁଲିସ ଇନଭେଷ୍ଟିଗେସନ କଲେ ଏବଂ ପୁଲିସ ଇନଭେଷ୍ଟିଗେସନ କରି ସବୁ ଥରୁଲି ଇନଭେଷ୍ଟିଗେସନ କଲା ପରେ ଦେଖିଲେ ମୋର ଲୋକେସନ ଟ୍ରାକ୍ କଲେ ମୁଁ ସେତେବେଳେ ଅଲରେଡି କଲେଜରୁ ତାର ବହୁତ ସମୟ ଆଗରୁ ଯାଇ ଉମଫେଡ କିଣିଲି ସେଠୁ ମଧ୍ୟ ସେମାନେ ଫଟେଜ ନେଲେ ତାପରେ ମୁଁ ଗଲି ମିସେସ କୁ ସେଠୁ ନେଇକି ଆସିଲି ଘରକୁ ଗଲି ଗାଡି ଧୋଉଛି ସେ ସବୁ ଗୁଡାକ ପୁଲିସ ଇନଭେଷ୍ଟିଗେସନ କଲେ କଲେଜରେ ଯାଇକି ସବୁ ଷ୍ଟାଫ ପଚରା ଉଚରା କରି ସାରି ମତେ ଆଉ କିଛି କହିଲେନି ପଳେଇ ଆସିଲେ ତାପରେ ଏବେ ପୁଣି ପିଟିସନ ଗୋଟେ ଦାଖଲ କରିଛନ୍ତି ବାରିପଦା କୋର୍ଟରେ ତାପରେ ଯେତେବେଳେ ମତେ ନୋଟିସ ହେଲା ତାପରେ ମୁଁ ପୁଣି ଆପଣଙ୍କ ପାଖକୁ ଆସିଲି ସାର୍ ଇଏ କରିବା ପାଇଁ
ଆପଣ ଯେତେବେଳେ you must be addressing him means you your senior you must be addressing him as sir na kon apun tangu dakon
ହଁ ସାର୍
ପ୍ରିନ୍ସିପାଲ ସାର୍
ଆଜ୍ଞା ସାର୍
ତ ଆପଣ ଯେତେବେଳେ ଜାଣିଲେ ଗୋଟେ ଆପଣଙ୍କ ପ୍ରିନ୍ସିପାଲ ସାର୍ ଗୋଟେ ଏଫଆଇଆର ଦେଇଛନ୍ତି ଆପଣଙ୍କ ନାଁରେ ତ ସେଇ ଦିନ କି ତା ପରଦିନ ହୁଏତ ଜାଣି ଯାଇଥିବେ ଆପଣ ଯାଇ ତାଙ୍କୁ ମିଟ୍ କଲେନି ଯେ ସାର୍ କଣ ଏମିତି ଆପଣ
ନା ସାର୍ ସେ ଏଫଆଇଆର ଟା ଗୋଟେ କାଉଣ୍ଟର ଏଫଆଇଆର କରିଛନ୍ତି ସେଟା ସାର୍ ତାମାନେ 12 ତାରିଖ ଦିନ ପ୍ରିନ୍ସିପାଲ ସାର୍ ଏବଂ ଆଉ 2 ଜଣ କଲେଜର ତାଙ୍କର ସାର୍ କୁ ଧରି +3 ଏକ୍ସାମିନେସନ ସେକ୍ସନ କୁ ପ୍ରିନ୍ସିପାଲ ମତେ ଡାକିଲେ 10:31 ରେ ଦେଇ କହିଲେ ପ୍ରଧାନ କୋଉଠି ଅଛନ୍ତି ମୁଁ କହିଲି ମୁଁ ଡିପାର୍ଟମେଣ୍ଟରେ ଅଛି କହିଲେ ଟିକେ ଆସନ୍ତୁ ମୁଁ ଯାଇକି ସେଠି ପହଞ୍ଚିଲି କହିଲେ ଏଠି ବସନ୍ତୁ ବସିଲା ପରେ କହିଲେ ଯେ 25/8/2022 ତାରିଖରେ ଆପଣ ଗୋଟେ ପରୀକ୍ଷା ଡ୍ୟୁଟି କରିଥିଲେ। କଣ ହେଇଥିଲା ସେ ପରୀକ୍ଷା ଡ୍ୟୁଟିରେ? ସେଠୁ ମୁଁ ରିମାଇଣ୍ଡ କରିକିରି କହିଲି ଯେ ସାର୍ ସେଦିନ ମୋର ଗୋଟେ ପରୀକ୍ଷା ଡ୍ୟୁଟି ଦିଆ ହେଇଥିଲା। ସେଇର 116 ଜଣ ପିଲା ଥିଲେ ଏବଂ 6ଟି ବଡ ବଡ ରୋ ଥିଲା। ଆମେ ଡ୍ୟୁଟି କଲାବେଳେ ସେଠି 8 ଜଣ ଲୋକ ଥିବା ଜାଗାରେ 6 ଜଣ ଲୋକ ସେଠି ଥିଲେ, 5 ଜଣ ଲୋକ ଥିଲେ। ତେଣୁ 6ଟା ରୋରେ କ୍ୱେଶ୍ଚିନ୍ ବାଣ୍ଟିବା, ଖାତା ଆଣିବା, ଦସ୍ତଖତ କରିବା ପାଇଁ ଟିକେ ସାର୍ ଅସୁବିଧା ହେଲା। ତେଣୁ ମୁଁ ଆପଣଙ୍କୁ ଆସିକି କହିଥିଲି ଯେ ନେକ୍ସଟ ସିଟିଂରୁ ସେଇ ରୁମ୍ ଗୁଡାକୁ ଅତି କମରେ 6 ଜଣ ଲୋକ ଦେଲେ, 8 ଜଣ ବଦଳରେ 6 ଜଣ ଲୋକ ଦେଲେ କାର୍ଯ୍ୟଟି ସୁରୁଖୁରୁରେ ହେଇପାରିବ। ସେଟା କହିଲି ସାର୍ 25 ଅଗଷ୍ଟରେ। ତାପରେ ମୁଁ କଲେଜରେ 26, 27, 28, 29 ରହିଲି। 29 ଦିନ ସନ୍ଧ୍ୟାରେ ମୋ ସାନ ଭାଇର ମିସେସ୍ ଏକ୍ସପାୟାର୍ଡ କଲା। ତାପରେ ମୁଁ 30ରୁ 11 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ଛୁଟିରେ ଥିଲି। 12 ତାରିଖ ଦିନ ସାର୍ ମୁଁ କଲେଜରେ ଜଏନ୍ କଲି। ସେ 12 ଦିନ ମୁଁ ଯୋଉ କଲେଜରେ ଜଏନ୍ କଲି, ପ୍ରିନ୍ସିପାଲ ସାଙ୍ଗେ ସାଙ୍ଗେ ମତେ +3 ଏକ୍ସାମିନେସନ ସେକ୍ସନକୁ ଡାକିଲେ ଏବଂ ଏଇ 2 ଜଣ ଲୋକ ସହିତ +3ର କିରାଣୀ ମଧ୍ୟ ସେଠି ପ୍ରେଜେଣ୍ଟ ଥିଲେ। ଏଇ କଥା ମତେ ଯେତେବେଳେ କହିଲେ, ମୁଁ ଏଇ କଥା ମଧ୍ୟ ତାଙ୍କୁ ଡେସ୍କ୍ରାଇବ କଲି। ଏଇ କଥା ସାର୍ ଡେସ୍କ୍ରାଇବ କରି ସାରିଲା ବେଳକୁ ସେ ଅନ୍ୟ 2 ଜଣ ଭୋଳାନାଥ ସାହୁ ଏବଂ ଗିରିଶ ଚନ୍ଦ୍ର ପୁଥାଳ, ଯେମାନେ ପ୍ରିନ୍ସିପାଲଙ୍କ ପାଖେ ପାଖେ ଥାଆନ୍ତି, ହଠାତ୍ ଉତ୍ତ୍ୟକ୍ତ ହେଇ ମତେ ମା ଭଉଣୀ ସହିତ ଜୋତାରେ ପିଟିବାଠୁ ଆରମ୍ଭ କରି ଦେଖି ନବାଠୁ କହିବାଠୁ, ଆମେ ଅଫିସର, ଆପଣମାନେ କଣ ଭାବିଛନ୍ତି, କାହିଁକି ଆପଣ ପ୍ରିନ୍ସିପାଲଙ୍କୁ କହିଲେ ଯେ ଲୋକ କମ ସେଠି ଅଛନ୍ତି, ଏମିତି କହି ପୁରା ପିଟିବା ପାଇଁ ଘୁରି ଆସିଲେ। ସେଠୁ ମୁଁ କାନ୍ଦଣାନ ହେଇକିରି ସେଠୁ ଉଠିଗଲି। ତାପରେ ମୁଁ 12 ତାରିଖ ଅପେକ୍ଷା କଲି, 13 ତାରିଖ ଅପେକ୍ଷା କଲି, 14 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ଅପେକ୍ଷା କଲି। ଯେହେତୁ ପ୍ରିନ୍ସିପାଲଙ୍କ ସାର୍ଙ୍କ ସାମ୍ନାରେ ଏତେ ବଡ ଗୋଟେ ଘଟଣା ମତେ ସେମାନେ ଅପମାନିତ କରିଛନ୍ତି, ନିଶ୍ଚିତ ପ୍ରିନ୍ସିପାଲ ସେମାନଙ୍କୁ ଡାକିବେ ଏବଂ ମତେ କହିବେ ସାର୍ ଯାହା ହେଇଯାଇଛି ଭୁଲି ଯାଆନ୍ତୁ। କିନ୍ତୁ ସେ କିଛି କଲେ ନାହିଁ। ତାପରେ 14 ତାରିଖ ଦିନ, 13 ତାରିଖ ଦିନ ମୁଁ ପ୍ରେସିଡେଣ୍ଟ ସବ୍ କଲେକ୍ଟର ଜିବିଙ୍କୁ ମଧ୍ୟ ଏକଥା ଯାଇ କହିଲି, ସାର୍ ମତେ ଏମିତି ଅପମାନିତ କଲେ। ସେ କହିଲେ ଆଇ ଏମ୍ ନଥିଙ୍ଗ ଡୁଇଂ, ସେମାନେ ମତେ ଅପମାନିତ କରୁଛନ୍ତି ଏବଂ ସେ ତ ମତେ କହୁଛନ୍ତି ହୁ ଆର୍ ୟୁ, ଆଉ ଆପଣ ଆମର ଅଥରିଟି ନୁହନ୍ତି, ଏମିତି ମିସବିହେଭ କରୁଛନ୍ତି, ମୁଁ ଆପଣଙ୍କୁ କୌଣସି ମତେ ସାହାଯ୍ୟ କରିପାରିବିନି। ଯଦି କହୁଛନ୍ତି ଏତିକି ସାହାଯ୍ୟ କରିବି, ମୁଁ IICଙ୍କୁ ଜଣେଇଦେବି, ଆପଣ FIR ଲଜ୍ କରନ୍ତୁ। ତେଣୁ ମୁଁ FIR ଦେଲା ପରେ ଇନଭେଷ୍ଟିଗେସନ ହେଲା। ଇନଭେଷ୍ଟିଗେସନ ପରେ ସେମାନେ ସେ କେସ୍ ଚାଲିଛି, ସେମାନେ 844/2022ରେ ବେଲରେ ସେ ଅଛନ୍ତି ସବୁ। ତାପରେ 15 ତାରିଖ ଗଲା, 16 ତାରିଖ ଦିନ FIR ଗୋଟେ ଦେଇଛନ୍ତି ଯେ ମୁଁ ତାଙ୍କୁ ଗାଳି ଦେଲି।
ସେଇ ଯୋଉ କେସଟା ଆପଣ ତାଙ୍କ ନାଁରେ ଦେଇଛନ୍ତି,
ଆଜ୍ଞା,
ସେ କେସର ପୋଜିସନ କଣ?
ସେଟା ସାର୍ ସେମାନେ ବେଲ ପରେ କୋର୍ଟରେ ଚାଲିଛି।
ମାନେ କଣ ତା ଦେହରେ ଚାର୍ଜସିଟ୍ ହେଲାଣି ନା ସେମିତି ଆପଣଙ୍କ କେସରେ ଯେମିତି କ୍ଲୋଜ ହେଇଯାଇଥିଲା ସେ କେସ୍ ବି କ୍ଲୋଜ ହେଇଯାଇଛି?
ନା ସାର୍ କ୍ଲୋଜ ହେଇନି, ସେମାନେ ଚାର୍ଜସିଟ୍
ଚାର୍ଜସିଟ୍ ହେଇକି କଗ୍ନିଏନ୍ସ ନେଇଛନ୍ତି।
କଣ ଅଫେନ୍ସ କଣ?
341, 294, 506, 114, 34 IPC.
Acha, whether they have filed any application before this court challenging the order of cognizance?
No. They are on bail.
No, they are on bail.
Yes.
That can be ascertained through the what happened to him.
Well, he is there in the court, my lord.
Yeah.
But no one is there to the assistant is not there. He has gone to take his meal, so that he is waiting there. No one is there.
System assistant is not there.
There, my lord. He is the person is telling, my lord.
Ei aku dakilo register CPC guda. All right, you just take your seat. କୋଉଠି କୋଉଠି ମୟୂରଭଞ୍ଜ ବାରିପଦା କୋଉଠି?
Item 1.
May I please, Your Lordship? This is my lord, CRL appeal, my lord. Pending the judgment on dated 21/11/2023, my lord. Under section, my lord, 3761, 3763.
What is this matter? Criminal appeal for?
RI 20 year, my lord.
20 years and 25,000 fine, 25,000.
Page 42.
Page 42.
Right, admit, call for the trial court record. Yes.
Let notice you.
He has not filed any application for
Right.
interim application. Let him file, we'll see. Yeah.
Item 2.
Obliged.
Apparent convicted convicted for 10 years, my lord.
What is the offense?
20B2 IC and Act, my lord. And fine, my lord, 1 lakh.
Admit, call for the trial court record. Deposition copy to be supplied. Interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Yes.
Item 3.
My lord, the appellant has been convicted for a
Where is Mr. Sharma? And that man. All calling.
Item 11.
Namaste.
What is your good name?
Gopal Chandra Behar, sir.
You are the principal of Uddala College.
Sir, at that time I was principal. Now I am a retired person.
So ଆପଣଙ୍କ ଏ ଆଗକୁ ଆସନ୍ତୁ, ପ୍ଲିଜ କମ୍। ସେ ଡକ୍ଟର ଆଲୋକ ରଞ୍ଜନ ପ୍ରଧାନ ଆପଣ କ୍ୟାମେରା ସାମ୍ନାରେ ରୁହନ୍ତୁ। ଆପଣ ଆପଣ ଦେଖିପାରୁଛନ୍ତି କୋର୍ଟ ପ୍ରୋସିଡିଂ ତ?
Sir.
ଆଚ୍ଛା, ଆଲୋକ ରଞ୍ଜନ ପ୍ରଧାନକୁ ଦେଖିପାରୁଛନ୍ତି?
हाँ सर, वो देखिए सर।
ଆଚ୍ଛା,
ନମସ୍କାର।
नमस्ते सर।
ସେ କେସ୍ ଫାଇଲ କରିଛନ୍ତି। ଆପଣ ଯୋଉ କେସ୍ ଟି କରିଥିଲେ ପୋଲିସ ପାଖରେ, ପୋଲିସ ଫାଇନାଲ ରିପୋର୍ଟ ଦେଲା, ତାପରେ ଆପଣ ଗୋଟେ କମ୍ପ୍ଲେଣ୍ଟ କେସ୍ କଲେ। ସେଇ କେସରେ କଗ୍ନିଜେନ୍ସ ନିଆଯାଇଛି, ଯୋଉଟାକୁ ସେ ୱାଶ କରିବା ପାଇଁ ପ୍ରେୟାର କରିଛନ୍ତି। ମୁଁ ତାଙ୍କୁ ପଚାରୁଥିଲି, ସିଏ ବି ଗୋଟେ ଆପଣଙ୍କ ନାଁରେ ଗୋଟେ କେସ୍ କରିଛନ୍ତି ଏଇ ଘଟଣାର କିଛି ଦିନ ପୂର୍ବରୁ, 2-3 ଦିନ ପୂର୍ବରୁ, ଏବଂ ସେ କେସରେ ମଧ୍ୟ ଆପଣ ସେ କେସର ପୋଜିସନ କଣ ବର୍ତ୍ତମାନ?
सर से केस विषय में किसी धारणा नहीं सर, मत किसी जणे नहीं एबे जो केसटा है ता विषय मत किसी जणे नहीं।
ନାଇଁ, ଆପଣଙ୍କ ନାଁରେ ଗୋଟେ କେସ୍ ହେଇଛି ବୋଲି ଜାଣିଛନ୍ତି ନା ନାଇଁ?
सर सेटा तो आगे नहीं थला सर, सेटा 2000
ହଁ, ସେ ଆଗରେ ହେଇଥିଲା ଯେ ଏଇ ଯୋଉ ଘଟଣାରେ ଆପଣ ଏତଲା ଦେଇଥିଲେ 16/9/2022 ରେ।
सर
ତ ଏଇ ଘଟଣା ପୂର୍ବରୁ ଆପଣଙ୍କ ନାଁରେ ଯୋଉ କେସଟା ହେଇଥିଲା ସେଟା କେବେ ହେଇଥିଲା?
सेटा सर 14 केसटा तो 12 से 14 रे से एफआईआर 14/9
ରେ ସେଇ କେସରେ ବର୍ତ୍ତମାନ ସେ କେସର କଣ ପୋଜିସନ କଣ?
सर से केसटा सर फाइनल कर देथिले तारे प्रोटेस्ट रे मु सर कहथि सर आउट केस।
ନାଇଁ, ଆପଣଙ୍କ ନାଁରେ ଯୋଉ କେସଟା ଆକ୍ସି କରିଥିଲେ ତାର ପୋଜିସନଟା କଣ? ଆପଣଙ୍କ ନାଁରେ ଯୋଉ ଆଲୋକ ରଞ୍ଜନ ପ୍ରଧାନ ଗୋଟେ କେସ୍ କରିଥିଲେ ବୋଲି କହୁଛନ୍ତି 2-3 ଦିନ ପୂର୍ବରୁ। ସେ କେସର ପୋଜିସନ କଣ ମୁଁ ଜାଣିବାକୁ ଚାହୁଁଛି।
सर से केस तो वर्तमान सुधा फाइनल ହେଇନି सर, ଚାଲିଛି कंटिन्यू କରୁଛି।
ସେ କେସ୍ ସେ ବିରୁଦ୍ଧରେ ସେ ଯୋଉ କେସଟା ହେଇଛି ତା ବିରୁଦ୍ଧରେ କିଛି ହାଇକୋର୍ଟ କୁ ଆସିଛନ୍ତି କି କିଛି ତାକୁ ଖାରଜ କରିବା ପାଇଁ କି ଏମିତି କିଛି?
ମୁଁ ସାର୍ ଯାଇନି।
ଆଚ୍ଛା, ସେ କେସର ନମ୍ବର କିଛି କହିପାରିବେ?
Uddala PS case 281 of 2022, madam.
ଉଦଳା PS କେସ୍ ନମ୍ବର
281 2022.
22 when it was lost FIR
डेट किस दिन आंदी? 14/9 এটা ନାହିଁ ମୋ ପାଖରେ।
14/9 अच्छा।
That is registered under section 341, 294,
341
294,
yes
323, 506, 114 and 34 IPC.
The informant is Dr. Alok Ranjan Pradhan. को कोर्ट रे पेंडिंग अछि सेरा?
एसडीजीएम कोर्ट उदड़ा।
एसडीजीएम कोर्ट उदड़ा। आपण से केस रे बेल घरी गलेनी बेल जो केसटा आपण को ना रे हेची से केस रे बेल गलेनी?
बेल रे अछि।
अच्छा तापरे आउ किछि आगेलाणी से केस रे ना नाही सेमति रहिछि
ଏମିତି ରହିଛି sir. Again.
अच्छा सो ମୁଁ ତାଙ୍କୁ ଉଭୟ ତାଙ୍କୁ ପଚାରୁଥିଲି ଏ ଘଟଣା ଯଦି ଆପଣ ମାନଙ୍କ ଭିତରେ ଯଦି ମିଳାମିଶା ହେଇଯିବ ତାହେଲେ ଉଭୟ କେସ୍ ଟାକୁ ଆମେ ସରି ଯାଇ ପାରିବ ତେଣୁ ଆପଣ ମାନେ ପ୍ରଚେଷ୍ଟା ଯଦି କରିବେ ତାହେଲେ ଏଇଟାକୁ ଆଉ ଗୋଟେ ତାରିଖକୁ ରଖିବା ନଚେତ୍ ମେରିଟ ରେ ଯାହା ଶୁଣାଣି ହବ ଆପଣଙ୍କ କେସ୍ ଟା ବି ଆପଣଙ୍କ ନାଁରେ ଯୋଉ କେସ୍ ଟା ହେଇଛି ସେଇଟା ବି କଟିବ ଆଉ ତାଙ୍କ ନାଁରେ ଯୋଉ କେସ୍ ଟା ହେଇଛି ସେଇଟା ବି କଟିଯିବ ତେଣୁ ସେଥିପାଇଁ ଆପଣ ମାନେ ଓକିଲଙ୍କ ଇଏରେ ବା ଆପଣ ନିଜେ ପର୍ସନାଲି କଥାବାର୍ତ୍ତା ହୁଅନ୍ତୁ ଆପଣଙ୍କୁ ମୁଁ ସମୟ ଦଉଛି ଏବଂ ଆପଣ ରିଟାୟାର୍ଡ କଲେଣି ଏସବୁ ଜିନିଷକୁ ଆଗେଇବା ଆପଣ ମାନେ ହାଇଲି ଏଜୁକେଟେଡ୍ पर्सन्स ତେଣୁ ଚିନ୍ତା କରନ୍ତୁ ଏ ବିଷୟରେ କଣ କହୁଛନ୍ତି ଆପଣ
ମୁଁ ବହୁତ ପ୍ରକାର sir torture ହଉଛି sir.
ନାଇଁ ସିଏ ବି ଆପଣଙ୍କୁ ଯାହା କହିଲେ ସିଏ ବି ଆପଣଙ୍କ ଦ୍ୱାରା ବି ଟର୍ଚର ହେଇଛନ୍ତି ତେଣୁ ସେଇ ପୁରୁଣା କଥାକୁ ଭୁଲିକିନି ଯଦି ଆପଣ ମାନେ ମିଳାମିଶା କରିବାକୁ ମନ ସ୍ଥିର କରନ୍ତି ଏବଂ ଏ ବିଷୟରେ ଓକିଲ ବାବୁ ମାନଙ୍କୁ କହନ୍ତି ତାହେଲେ ଉଭୟ କେସ୍କୁ ମଧ୍ୟ କଟିଯିବ ତେଣୁ ଏ ବିଷୟରେ ଚିନ୍ତା କରନ୍ତୁ ଆପଣ ତାଙ୍କ ଓକିଲ ତ ଏଠି ଅଛନ୍ତି ଆପଣଙ୍କର ଓକିଲ କିଏ ସେ ବିଷୟରେ କଥାବାର୍ତ୍ତା ହୁଅନ୍ତୁ your advocate is sitting by your side
Exactly sir.
what is your good name learned counsel
असित कुमार होता
असित कुमार होता
सर ये फाइल की भोगलत ना
okay in this particular case you have filed
minor
CRL
CRL 620 of 23
so in that case which was instituted against your client whether charge sheet has been submitted
no sir charge sheet is not yet been submitted.
So here Mr. Bigyan Sharma is appearing for Dr. Alok Ranjan Pradhan. So both of you talk and about this suggestion given. I'm taking up this matter some other day and your phone number please give it to Mr. Sharma and so that both of you can talk with your client and made a video conferencing so that if it can be sorted out or you tell on the next day what is the final. So I'm keeping it 2 weeks after on 29th I'm keeping. So you have already filed, Mr. Ota, you have already filed Vinama in this RLA.
Yes, madam.
Okay. Take down. As for the order dated 2/4/2024. Appellant Dr. Alok Ranjan Pradhan has appeared in person. The respondent number 2, Gopal Chandra Behera, who is the informant in Udala PS case number 283 dated 16/9/2022. Is also present through virtual High Court Mayurbhanj at Baripada. During course of interaction, it came into light that the appellant, Dr. Alok Ranjan Pradhan, instituted a case against the respondent number 2 at Udala Police Station on 14/9/2022, which was registered as Udala PS case number 281 of 2022 under section 341, 294, 323, 506, 114 by 34 of the Indian Penal Code. And it is now sub judice in the court of SDGM, London SDGM Udala. Respondent number 2 submitted that in the said case, he has already been released on bail and charge sheet has not been submitted. The respondent number 2, who was the principal in charge of Udala College on the date of occurrence, is stated to have retired in the meantime. The appellant, Dr. Alok Ranjan Pradhan, is now working as reader in chemistry department of Udala College, Udala. Mr. Asit Kumar Ota, Land Council, appears through virtual mode from the virtual High Court Mayurbhanj at Baripada and submits that he has already filed Bhinama for the respondent number. The Bhinama be placed on record and the name of Mr. Asit Kumar Ota be reflected in the cause list henceforth. So also in the on the top of the brief. Since both the appellant as well as the respondent number 2 were working in the same college and they are highly educated, and it appears due to some misunderstanding the case has been instituted, both the cases have been instituted, suggestion has been given to the parties to amicably settle the matter. It is expected that the London Council representing them shall cooperate to see that matter got amicably settled. Put up this matter in the week commencing from 29th April 2024. The appellants, also the respondent number 2, shall appear in person on that day, and the London Council for both the parties shall apprise this court about the development made, if any, in the meantime. A free copy of the order be handed over to the London Council for the state, who will obtain the status of Udala PS case number 281 of 2022. Yes. So call that system assistant. Yes, all right. That please go. Call that system assistant. Who is there? In that virtual High Court. System assistant, call him to the front. Why? Where have you gone? Kodi jaitlo tame.
Signature mari ke asla sa late hegala.
What is the time of your duty?
10.
So today court when make a query at about 10:45, you are also not there. What is your explanation? I have asked the CPC to take note of it, and henceforth, if any such situation comes and is reported, appropriate action will be taken against you. Yes.
Item 4. Item 6.
May it please your lordship. Item number 6, my lord. The operative part is page number 52, my lord. The learned court below directed undergo RI for 10 years and to pay fine of rupees 1 lakh and in default further period of 1 year, my lord. In 20B2C, your lordship. Earlier, this petitioner granted bail by this honorable court by BLPL number
All right,
9456.
admit call for the trial court record. Deposition copy to be supplied.
Already supplied, my lord.
Deposition copy stated to have already been supplied. Interim applications for bail and stay relation of fine to be considered after receipt of the trial court record. Yes.
Grateful, your lordship.
Deposition copy they have supplied. Yeah.
1 to 4. Only 4 witnesses are there.
Yes. Next.
Item 7.
May I please your lordship. My lord, attorney.
Item 8.
Present appellant is the informant, my lord, challenging order dated 18 January 2024. My lord,
What is the sentence and
my lord, the only sentence under section 363 IPC, sentencing him to undergo rigorous imprisonment for 3 years and to pay fine 10,000 only, my lord. And acquitting the offense under section 363, 450, 376 to N 376 3.
you were on bail during trial?
I am the informant, my lord.
Sure. No, he has been found guilty. So
Only lesser offense under section 363.
okay.
Acquitting
What is your instruction about challenging the conviction before this court?
My lord, before this honorable court, it is CRLA number 147 of 2024.
CRLA
147
of
2024.
You have already entered appearance in that case?
No.
Why don't you know appearing?
Yes, no.
He has been released on bail by this court.
For us,
147 Bharkalo, CRLA number. (147) 2024. What order was passed in 4/3/24 years? Roll down. Okay. Roll down. Roll down. Okay, he has been granted bail also in that case. Learned counsel for the appellant submitted that the appellant is the informant in Marsaghai PS case number 428 of 2021, and one Jitu Ranjan Pradhan alias Gana faced trial in GR case number 125 of 2021 in the court of ad hoc additional session judge FTSC Kendrapada for offences punishable under section 366, 450, 376 2N, 376 3, 506 IPC, section 6 of the POCSO Act, and section 31R bracket W I oblique 32B oblique VA of the SC/ST PO Act. And the said case arises out of Marsaghai PS case number 428 of 2021. The London Trial Court by judgment and order dated 18th January 2023 has been pleased to acquit the accused of all the charges except section 363 of the Indian Penal Code, and sentenced him to undergo RI for 3 years and to pay a fine of rupees 10,000 in default to undergo RI for a further period of 6 months. This criminal appeal has been filed under section 372 of the CRPC, challenging the acquittal order of the respondent number 2, Jitu Ranjan Pradhan alias Gana, of the offences as stated above. Stop. It is stated that the respondent number 2 has already preferred criminal appeal before this court, challenging the conviction order passed by the London Trial Court under section 363 of the Indian Penal Code in CRLA number 147 of 2024. And in the said case, the appeal has been admitted and he has been granted bail. And scroll down. And realization of fine amount has been stayed. This court thinks it be proper that both the matters are to be heard together, and accordingly list this matter along with CRLA number 147 of 2024 in the week commencing from 29th of April 2024. Take down another line. The London Council for the state shall obtain instruction as to whether the state is intending to prefer any appeal challenging the order of acquittal of the respondent number 2 of the offences as stated to above. Free copy of the order be handed over to the London Council for the state.
Item 9.
May I please, Your Lordship. The maximum sentence is RI for 10 years for the offences under section 376
10.
Appellant was convicted under Section 13 of the PC Act, read with 409. So far 13 1 CD is concerned 3 years sentence, my lord, and so far 409 is concerned 4 years maximum punishment 4 years, my lord, and he was on bail, my lord. Lordship, page 87, running page 87, judgment page 74. Lordship,
sentences are to run concurrently.
Concurrently.
You were on bail during trial.
Yes, yes. Page 85, Your Lordship, kindly see. The convict Ramesh Chandra Sahu is produced from custody and other accused Gaurav Raut is present in the court as he was on bail. Running page 7, judgment page 72.
Yes, Mr. Das.
Yes, my lord, I have received the copy and I will file my appearance now by the end of May, my lord.
Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, submits that he has received the copy of the appeal memo along with the impugned judgment and copies of the interim applications, and he will file his appearance memo by end of so on. Hard admit he was on bail. The maximum sentence
4
is
years.
4 years. After conviction, he has been taken into custody. So bail allowed, stay realization of fine, free copy of the order be handed over to Mr. Das. Yes.
Okay.
Item 12.
May I please? Fortunately, last time my direction, I have filed a comprehensive affidavit. But I see the last order.
Last order is dated 2/4/2024. Learned counsel for the appellant submitted that the appellant is similarly situated like co-accused Bismay Behera, alias B2, who has been granted bail by this court in CRLA number 1226 of 2023 by order dated 12/3/24. And counsel for the state on verification of the case diary, particularly the statements of eyewitnesses Goparanjan Sahu and Pintu Bhoi, fairly submitted that the appellant is similarly situated like Bisma Behera. But the appellant has got two criminal antecedents. One is of the year 2000, the other is of the year 2021, and the latter one was under section 307 IPC. And counsel for the appellant submitted that he has instruction that in both the cases the appellant has been granted bail, and he will file a comprehensive affidavit along with this answer. So what you have done?
One case, the magistrate has granted, another case the sessions court has granted. I have also filed the certified copy of the
Yes, Mr. Das. Heard the learned counsel for the petitioner, learned counsel. The learned counsel for the appellant submitted that the appellant is in judicial custody since.
I'm in custody, 1/5/2023. 1/5/2023.
1/5/2023. And he has been charge seated under section.
Charge seated. Yes, ma'am. What is 147, 148, 323, 326, 302, 307, 153A, 506, 149 IPC, read with section 31R, 32V, VA of SC and ST Prevention of Atrocity Amendment Act 2015.
The learned counsel further submits that the petitioner is similarly situated like co-accused Bismay Behera alias P2, who has been granted bail by this court in CRLA number 1226 of 2023 by the order dated 12/3/2023, which is not disputed by the learned counsel for the state after verification of the case record. And as per the statement of the eyewitnesses, namely Goparanjan Sahu and Pintu Bhoi. The Learned Council for the state, when the matter was taken up on 2/4/2024, the Learned Council for the state pointed out that there are two criminal antecedents. One is of the year 2020 and the other is of the year 2021 against the appellant. The Learned Council for the appellant was asked to file the comprehensive affidavit relating to the status of those cases. And counsel has already filed a comprehensive affidavit wherein it is stated that in both the cases he has already been released on bail and bail orders have been annexed to the comprehensive affidavit. Considering the submission made by the Land Council for the respective parties, the nature of accusation against the petitioner, period of detention in judicial custody, and similarly situated co-accused has been released on bail, I am inclined to release the petitioner appellant on bail allowed. Yes. এটা নোটিস তো সাফিসিয়েন্ট হয়ে যেতলা না ইভেন দো উপর লিখ দেবে notice is made sufficient non-appeals for the appellant है ना yes
Item 13.
Maybe juvenile
Meanwhile, the co-accused who assaulted the deceased has already been released on bail by CRL REV number 98 of 2024.
Right.
He is the main accused who assaulted by means of an bottle.
Learned counsel for the state seeks some time to obtain the case diary. Also the social investigation report.
Lordship, I have annexed the social investigation report, Lordship.
Oh, case diary asu.
Yes, sir.
Social investigation report kitten annexure kitten.
Annexure 5, Lordship.
Annexure 5. Acha.
Page 44, Lordship.
That is there.
44.
44 to 40. The learned counsel for the petitioner has annexed the social investigation report. Therefore, the learned counsel for the state shall only produce the case diary in the next date, which is fixed to 22nd of April 2020. Yes.
Obliged.
Item number 22.
May I please, my lord. On behalf of Miss Pratyusha, may I permit for submit, my lord.
This press matter.
Yes, my lord.
Oh.
This is a case of POCSO.
Have you got the case diary?
No, madam. First time.
Juvenile bail matter.
Yes, my lord.
So CD social investigation report. Yes.
Item 23.
May I please, my lord. Praying for peruse the order dated 21/3/2024, my lord.
Yes.
Yes, my lord.
Loko kodi haro.
Man of Bihar, my lord.
So since when you are in custody?
Lord, 8/6/2021, my lord.
And what are the offenses under which charges submitted?
My lord, 20B2C 29.
Earlier you have never been released on bail.
No, my lord.
And but did you approach this court earlier?
Yes, my lord. That is 2661. That has been withdrawn, my lord.
Now, what is the position of the
Position, my lord, trial not commenced, my lord.
report was called for from the where is that report? Status report. No, the report indicates that out of 32 charge sheet witnesses, 6 witnesses have been examined. That report is dated 8/11/2023. What about the criminal antecedent?
Yes, my lord, antecedent, my lord.
You have got criminal antecedent.
In the rejection order it was reflected, my lord. But till today, the he has not remanded in that criminal antecedent, my lord.
No. You have so many NDPS Act cases, sir.
Yes, my lord. That is page 22.
No.
But in all the cases, remand has not read, my lord.
File a comprehensive affidavit.
My lord, I will file the comprehensive affidavit, my
Like
lord.
on the
But one prayer, my lord.
yes.
My lord, he is the accused is suggesting that I am not involved. So
Whatever you want to mention it in that affidavit. That will be verified.
Yes,
all these cases against you are under 20B2C.
I have annexed also one FIR, my lord.
Look on
My
the
name is
rejection. Learned Counsel for the state has produced the written instruction received from IIC Mohana police station, which indicates that the two local sureties, namely Libya Maji and Ugrasen Maji, are willing to take the petitioner on bail. And these documents of the two local sureties were also verified and it was found to be genuine. The report furnished by the IIC Mohana police station is taken on record. On perusal of the rejection order, it appears that there are a number of cases instituted against the petitioner under section 20B2C of the NDPS Act. Learned Counsel for the petitioner seeks some time to file a comprehensive affidavit relating to the status of those cases. The status report submitted by the Learned Trial Court is dated 8/11/2023, which indicates that out of 32 charge sheet witnesses, 6 witnesses have been examined. Since in the meantime, five months have already passed, let a fresh status report be obtained from the Learned Trial Court, and for such purpose, file be placed before the Learned Register Judicial. Matter be listed in the week commencing from 29th April 2024. So, it out of. I'm just coming within 2 minutes.
Lord, praying for correct the cause title, my lord. GR case number instead of 2020, it was typed, my lord.
Correction कर दो. GR case number from first title correction करिए, permission is granted. Yes.
Item 24.
Ready? May Twenty-one 3/2024, my lord. Father of the petitioner sent one affidavit, but he has not given the bail orders, my lord. And praying for some time, my lord. Apart from that, my lord,
You have got 13 criminal
yes,
antecedents, and it's a bail application of the year 2022.
yes, my lord.
Rejection order is dated 28/6/2022. So almost 2 years it is pending now before this court. And you are seeking for adjournment.
No, my lord, I am not adjournment.
Then
but,
what it is?
The father of the petitioner supplied a copy of the affidavit, comprehensive affidavit, my lord, but he has not given the entire bail orders, my lord.
Variety of cases are there. 302 and
In all cases, he has done bail, my
307,
lord. This is the affidavit.
395, NDPS Act 20B2C, whatnot. Every varieties of cases are there.
302 also there.
That is I am telling.
3 to 4.
302 cases, number of 302 cases,
Accurate.
then 20B2C, then 395. So export in every line.
In that 302 case, my lord, he has acquitted, my lord, in that affidavit.
And counsel for the petitioner and counsel for the state in view of the criminal proclivity of the petitioner. I am not inclined to release him on bail. The London trial court shall do well to expedite the trial. Yes, next.
Obliged.
Item number 27.
My lord, earlier occasion, as per the direction, my lord, I have already filed the documents of the surety who will, my lord, and your lordship was also pleased to have this matter in the instance of the other co-accused persons and was pleased to allow the bail application, my lord. And
No,
thus,
no, when you supplied the name, address, and documents of two local courts,
yes, my lord, that I have already.
any instruction has been taken?
Again, that I have supplied, my lord, on 3/4/2024. Receipt is
Supplied, it has not come to the file.
Okay, 3/4 in the
yes, my lord.
office
Receipt,
of PCT.
yes, my lord. Receipt is also.
So, Mr. You take the
Yes,
receipt
sir.
photograph and see that it is sent to the
Yes.
as per the direction
I would have been
that IIC is to verify and send the report.
Receipt this.
I would have copy extra copy.
Okay, give it another.
Yes.
And there is another direction to verify the address of whether the address is correct or not. What instruction you have received? Because this man is from Uttar Pradesh and
Yes, madam. That has sent to the SP.
SP Gajapati is to make necessary communication with the SP Aya Raya, Arya district.
My lord, the same person who I have filed the document, the same person also stands for another accused person. Your lordship was pleased to allow. I have handed over the copy, and then his bail application is accepted. Same person, my lord, driver and helper. Your lordship was pleased to allow the driver.
They are professional bailers.
ନାଇଁ ସେଇ ଡ୍ରାଇଭର କୁ ହିଁ ନେଇଥିଲେ ଏବଂ ସେ ତାଙ୍କରି ଗାଁ ଲୋକ ସେଠି ସେ ରହୁଥିଲେ ତାପରେ ସେ ହେଲ୍ପରକୁ ନବା ପାଇଁ ସେଇଟା
Yes,
ଡକୁମେଣ୍ଟ
the London Council for the appellant submitted that the petitioner submitted that in the AG office, the name, address, and documents of the local sureties have already been filed on 3rd of April 2024. The Land Council for the state submits that he has to verify the same, and if it is already there, he will take steps for compliance of the order dated 14/3/2024, including to ascertain the correctness of the address furnished in the cause title of the bail application as per the said order. Put up this matter on recommencing from 29th April 2024. Next.
Number 28.
28 man last occasion taking
And I want to take time as you were appearing through his prisoner petition first time consent matter, and I have no also petition also not available with a copy of the petition maybe.
You want the copy of the petition?
Yes,
All right. Mr. Sarthak Naik, Learning Special Public Prosecutor for CBI, is present through virtual mode. The name of Mr. Naik be reflected in the cause list henceforth. Mr. Smruti Ranjan Raut, Learned Counsel appearing for the petitioner, submitted that he has been engaged recently and he is not having the copy of the bail application. Let the registry supply the Xerox copy of the bail application along with all the annexures to Mr. Raut by next week. Put up this matter in the week commencing from 29th of April 2024. The names of Mr. S. Devabrata Reddy, A. Mahanti, A. Koro shall not be reflected in the cause list henceforth. Yes.
Item 30.
Plead the lordship. My lord, to comply with the order dated 21st March 2024, the petitioner furnished the bail particulars along with the affidavit as well as the affidavit shown by the wife of the petitioner, and copy also served to the land AGB on 2/4/2024.
Petitioner seeks some, State Council seeks some time to, petitioner took time to furnish the names, address and documents of two local sureties. ଆପଣ ଦେଲେ କି? ବାକି ଦ୍ୱିତୀୟ କଥା ହଉଛି ଆଡ୍ରେସ ର ଯୋଉ କରେକ୍ଟନେସ୍ କୁ ଭେରିଫାଇ କରିବାକୁ
shown an affidavit is also submit the transfer certificate of the petitioner along with other documents, and copy has already been served to the AG.
Learned Counsel for the Mr. Guru Prasad Behera, Learned Counsel, appearing through virtual High Court Baleshwar, and he submits that on 2/4/2024 he has already furnished the names, address and documents of two local sureties in the AG office. Learned Counsel for the state seeks some time to obtain instruction as per the order dated 21/3/2024 through the inspector in charge of Dhenkanal Town Police Station. The Learned Counsel for the state has produced the written instruction received from Superintendent of Police Dhenkanal wherein it is mentioned that the verification of correctness of the address of the petitioner was called for from SP Jhargam in the state of West Bengal, and it has been reported that the address of the petitioner is incorrect. Learned Counsel for the petitioner shall obtain instruction on this aspect and file the correct address of the petitioner. Mr. Behera.
Files documents.
तापर इंक्वायरी करिकी से करेक्ट एड्रेस टा से पुलिस देई.
Acha, the correct address is Puda.
Amaso.
During inquiry, it came to light that Balaram Das, son of so and so is totally incorrect. Okay. Inquiry officer collected the certificate of Pradhan of Khari Khamani Gram Panchayat in favor of the okay. In course of inquiry, it revealed that Balram Das, son of Parmanand Das, is a permanent resident of village Khamasol under NNO Swanso under Swanso. Okay. So you are to mention this address in your cost title.
My lord, I have mentioned in my in the address in cost title as Khodika, and because charge sheet is submitted Khodika.
সেটা ভুল আড্রেসটা পুরা বুঝি পারলেনি কি সেটা আসিলা যে সেটা ভুল আড্রেস এবং ଆପଣଙ୍କ କରେକ୍ଟ ଆଡ୍ରେସଟା ମଧ୍ୟ ସେ ଦେଇଛନ୍ତି ସୋ ଏଇ ଅନୁଯାୟୀ ଆପଣ ସେ କରେକ୍ଟ ଆଡ୍ରେସଟା ଇନସର୍ଟ କରିବେ କଷ୍ଟ ଟାଇଟେଲରେ you have got any associate, ask them to do the same in court today, or you can come to the registry and correct it.
In the course of the day, I will find.
Okay. The incorrect and correct address of the petitioner has been also furnished in the said report. The Mr. Behra submits that he will take steps to correct the address of the petitioner in the cause title of the bail application. Put up this matter on such and such date. Baki se order do. Yes.
Item 31.
Kota kare. No. See very see address ta mention kar.
31 में लॉट
हाँ ठीक है 26 ना हाँ 26/4/2024 and Mr. Tripathi will obtain instruction on those documents which are filed about the local security in the meantime. Yes, Mr. Panda.
Yes, my lord, last two occasions, my lord, directed to my lord and senior state counsel take instruction whether the petitioner, my lord, misused the liberty while he was granted interim bail.
Interim bail granted in this case or in previous case?
Other two
Achha.
cases.
You are granted interim bail on 2 occasions.
Yes.
And you surrendered after availing the same.
Custody near about
anything reported against him? The accused is residing so and so during interim bail period. The accused neither appeared at Jatni police station nor criminal case has been instituted against one. Accused resigning, ISC may be asked to.
Custody 19/6/2020. Report 19/6/2020. Out of 15 witnesses, only 3 witnesses examined.
Report kain?
Earlier order dated me lord 10/11 पूर्व trial court order
21C 2529 of the NDPS Act. Okay. And out of 14 charge sheet witnesses, 3 witnesses have been examined. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the state has produced the written instruction received from IIC Jatni Police Station dated 25/3/2024. In terms of the order dated 14/3/2024, which indicates that during interim bail period, the petitioner, that no criminal case has been instituted against the petitioner in Jatni Police Station. The report is taken on record. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 19/6/2020 and twice he has been granted interim bail. And on each occasion, after availing the same, he surrendered at right time. He further submits that out of 15 charge sheet witnesses, 3 witnesses have been examined, and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail. Here is the status report submitted by the Learned Trial Court, Kerala, which indicates that out of 14 charge sheet witnesses, 3 witnesses have been examined. Considering the submission, so also 3 months bail granted. Yes.
Then item 32 and 33, I am praying Lord next week because 32 I have to take instruction regarding the stage of trial. Then 33 Lord, in the meanwhile, informant and other seizure witnesses examined. I have to produce the deposition.
Item number 32, Mr. Pandar, Learned Counsel appearing for the petitioner, seeks some time to obtain instruction about the stage of trial. Put up this matter on such and such date. Item number 33, Mr. Pandal and Counsel appearing for the petitioner submits that he has instruction that some witnesses have been examined in the trial court and he will produce the certified copy of the deposition on the next date. Put up this matter on such and yes.
Item 34.
Please, Your Lordship. By order number 1 and 3, Your Lordship has called for the address verification.
The report was called for from the number.
Positive.
So the report says that report is dated 18/3/24 and it indicates that Bolha Mrutyunjay Barik out accused.
Yes, Your Lordship. There are all total 6 accused persons.
नहीं से accused interim bail दिया है surrender colony NBW has been issued.
In fact, he was not a fair named accused. Later on, might have my lord. I have filed the charge sheet which doesn't indicate his name. That charge sheet might have been filed later on.
In this case, 3 witnesses have been examined. That is the report of 21st March 2024.
And the charge sheet indicates there about 17 witnesses.
No, that has been shortlisted. The prosecution might have filed a memo to decline the repetition.
Well, and I am in custody, as Your Lordship seen, November 2020.
What is the date of custody?
11/11/2020.
What are the offenses under which?
Offenses, my lord, 22C, my lord, and the exact allegation that
20B, 2C, 29 of NDPS Act and 389, 34 IPC.
So far as the allegation of NDPS that has been attributed against me and two other persons. The allegation is that a vehicle was kidnapped or taken forcibly to a isolated place. And the persons, those who are present at the isolated place, demanded 3 lakhs from this present petitioner and another person that unless you pay this money, you will be handed over to the police. At that moment, police conducted the raid or red-handedly. Those who are giving threat as well as the petitioner and the others.
You were taken into custody on 11/11/20.
Yes, sir, lords.
And have you been ever released on interim bail? Okay, but you are a man from
Andhra Pradesh.
Andhra Pradesh, so you are to give the local security document.
Your lordship has also called for the address verification.
Address verification, ठीक है जी, सेटा
Local security I can be. Well, it's very adjacent. That your lordship.
Learned Counsel for the state has produced the written instruction received from Superintendent of Police Koraput. The address here ठीक अछि तो Mr. Tripathi?
No.
That the address is correct. The same is taken on record. Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 11/11/2020 and he has been charge sheeted under section 20B2C 29 of the NDPS Act and 389 by 34 of the IPC.
My lord.
Right? Stop. Let the Learned Counsel for the petitioner supply the names, address, and documents of the local security to the Learned Counsel for the state, and the same shall be verified through the inspector in charge of Jaipur Sadar Police Station. Put up this matter on such and such date. Address verification, security verification. By what date you will supply this?
Next week, my lord. In fact, I have got, but those are not properly legible. That's why I am not supplying
names, address, and documents to be supplied by next week.
My lord.
Yeah.
And 35.
My pleasure, lords.
granted me to after examination of the victim well. I have
Earlier you approached this court.
Yes, ma'am.
What is the number?
Number of that is 5008 of 2022.
Okay, I have got it, and it shows that it's a case of rape, and the rape was committed on the victim, who was a blind girl. She became pregnant on account of rape, and that is the reason why the bail was refused, and liberty was granted to you to renew the prayer for bail after examination of the victim.
My lord.
So what is the position now?
Now, the examination of the victim, I have given the deposition, my lord.
PW?
Annex of 3.
PW1,
1.
page
1.
15.
Starts from 15 and the cross
Yes.
examination 16, my lord. Everything is a married lady. She was sold by her.
Accused promised me to marry and committed rape on me. Made me pregnant for 7 months. The accused committed rape, so and so. I told my grandmother, so and so. Okay. Yes, what do you want to
Cross
point out?
examination, lordship.
Which paragraph?
Page 16, my page 16.
1-6. Yes.
1-6.
Which paragraph?
Para 7.
Mr. Tripathi, is
Yes,
it
ma'am.
available with
Yes, yes.
I can't page 7 at the phone. Yes, I had. Please place it.
I had married earlier to another Jagdish Sahu of village Uktapur in a temple of Lord Rameshwar at Baleshwar in presence of my mother on 29th in the month of Margashira 2018, and that Jagdish Sahu is Ali. I am putting vermilion on my forehead in view of such marriage with the said Jagdish Sahu. I had filed case for maintenance against the said Jagdish Sahu. After he deserted me, he did not look after me nor provided maintenance to me. Thereafter, my mother sold me at 1 lakh rupees 1 lakh at Bombay. I stayed there for 1 year at Bombay in the year 2018. As I was subjected to physical abuse, I came back to the Bombay stealthily, and one of the persons who kept physical relation with me at Bombay is me to Mumbai. I came to Baleshwar from Mumbai.
Meet to Mumbai.
Meet to Mumbai.
ये की?
ये is a
Another person that is from Mumbai.
Mumbai.
After I became pregnant for 7 months, I filed the case in the police station.
The president.
So
victim is a dancer in the Jatrapati, and there is a relationship with the present petitioner.
No, no, this particular line, Mr. Tripathi.
Yes, my lord.
ये जो लाइन टा कहिला जे बॉम्बे रे जेतेबेले थिला जने फिजिकल रिलेशनशिप तांगरे रखी थिला मीट टू मुंबई. Then I came to Baleshwar from Mumbai. So how it can be said that she got pregnant whether on account of the petitioner or that meet to Mumbai?
There must be child, my lord. That is the 7-month pregnant at the time of giving FIR.
What she has stated about the child?
Not put a question in that.
So what is your instruction about that child? Whether she delivered any child?
That is not there, my lord. I will take instruction on that.
All right. Period. The evidence of the victim was examined in the trial court as PW1. In her deposition, she stated that on account of commission of rape on her, she became pregnant for 7 months. Since nothing has been stated about the status of pregnancy in the deposition, London Counsel for the state seeks some time to obtain instruction in that respect. Put up this matter in the week commencing from 22nd April 2024. Yes.
Item 37.
37 my lord. Present petitioner is in custody since 23/2020, more than 4 years, my lord. The background of the case is, my lord, and
You have received the case diary?
Yes, Ullah. Yes.
the background
Wait, just. So how many times you have approached this court earlier?
4 times, my lord.
So any order of interim bail you have received?
Twice I have been.
Last time when you received that?
That is 7286 of 2023.
And you are released on bail for a period of
3 months.
3 months.
Two bail application, 3 months.
So you surrender at right time.
Right time. And
So, what is the position of the trial now?
trial manner, as your lordship observed in the bail application, out of 25 witnesses, only 9 witnesses has been examined. No further development is there.
No, ये जो 12/10/2023 रे
ଆଜ୍ଞା
ଆପଣଙ୍କୁ ମୁଁ ବେଲ୍ ଦେଇଥିଲି 3 ମାସ ପାଇଁ।
3 ମାସ ପାଇଁ ତାପରେ ଆଉ କିଛି ଡେଭଲପମେଣ୍ଟ ହେଇନି।
So, Mr. Tripathi,
Yes, Ullah.
you obtained instruction about that whether he has misutilized the liberty during that interim bail period. Learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on
Judicial custody. I'll give the date, my lord. I will give the date immediately.
and he has been released on interim bail twice.
Twice, my lord.
And last time he was granted interim bail for a period of 3 months in BLAPL number 7286 of 2023 as per order dated 12/10/2023. And after availing the same, he surrendered at right time. Stop. The Learned Counsel for the state seeks some time to obtain instruction through the inspector in charge of Barpali police station as to whether during the period of interim bail there is any allegation of misutilization of liberty by the petitioner or not. Stop. In the meantime, let the status report be called for from the Learned Trial Court, and for such purpose, I will be placed before the registered judicial. Yes, this matter will be commencing from 22nd April 2024.
22nd.
22/4/2024 ହେଲା।
Interim bail अबिका prayer करिपरिबे ना after 22.
कोनटा?
Because he has some family program. Can I pray for interim bail or
No,
after
let
notice?
it come. Family program माने कोन?
ବାହାଘର ଅଛି ଭାଇ।
କାହାର?
ଭାଇର ବାହାଘର।
କିଛି ତ ଦେଇନାହାନ୍ତି ଆପଣ।
ଦେଇନାହିଁ ମୁଁ ଖାଲି
No,
moral-
interim bail if you file, then instruction can be obtained. Otherwise, it is not.
I understand.
Yes.
Item 38.
May proceed. So lordship granted
Yes.
bail to the coacted persons.
Huh?
Since your lordship granted bail to the coacted persons,
Hmm.
this application has been listed. I have annexed under Annex 3 series. First bail application BLAPL number 2091 of 2020. Your lordship granted bail to accused Tahsil Korua and rejected the prayer for bail of Amar Singh Korua, and the page 19 paragraph 3 is the relevant portion. And subsequently, your lordship
The
granted
nature of accusation against petition number 2, namely Aman Singh Karwa, is extrajudicial confession and recovery of the weapon of offense and postmortem report finding.
Then, my lord, your lordship, next BLAPL number 684/2021, your lordship granted bail 3 months to him.
Kagu.
Say Amar Singh Korwan. Subsequently, my lord, page 24, after examination of that particular witness of extrajudicial confession, your lordship granted bail to him. There are 5 accused persons are there, and so far as the cause of death is concerned, the allegation that 5 persons.
No, 2 have been already granted
Yes,
bail.
ma'am. Now 3.
Now 3. So there is no direct evidence.
No.
So that extrajudicial confession, which was the reason for rejection of the earlier bail application.
Yes. Yeah, Amar Singh Korua.
Huh?
He has been examined as PW2. have given the depositions on last occasion. And the cause of death is, my lord, the brain hemorrhage, and the deceased has sustained 3 injuries, out of which one is caught over the occipital region, head.
Learned counsel for further submitted that the second bail application decision. The witness to the extrajudicial confession, namely Vishwanath Korua alias Abhi, has been examined as PW2 and he has not supported the prosecution. Mr. Tripathi,
Yes, sir.
say it a case based on circumstantial evidence. And
last in theory also there.
That PW2 is the witness to the extrajudicial confession and he has not supported the prosecution case for which the bail was granted to the co-accused Amar Singh Karwa. Yes. Gote to anare kon achi
gote hoche last scene theory.
Last in theory.
It's not that 164 statement I am reading, who accompanied to the deceased. More namo Nilambara Korua.
First tell that what is the date since when these persons are in custody?
Custody since, my lord, we arrested letter on 17/8/2023.
What are the offences under which charge sheet submitted?
341/302 by
341/302
by 34 of the IPC.
34 IPC. And what is the name of the deceased?
Sridhara Korua.
Korua na Korua?
K-A-R-U-A-N. Korua.
Date of occurrence?
Occurrence is, my lord, 5/9/2019.
This PW2 who was examined, it is in your case or in the respect of the
that is reflected in the rejection order.
So last in Sakhi kiye?
Nilambara Korua and Pitambara Damsan.
Nilambara Koro.
Korua.
Korua.
And Pitambara Damsan.
ସେ କଣ କହିଲେ ସେ ଯୋଉ
ମୋର ନା ନୀଳାମ୍ବର କରୁଆ, ବୟସ 54, ମୁଁ ଘାଗରୁଲି ଗ୍ରାମରେ ବସବାସ କରେ। ଆଜି ଆପଣଙ୍କ ଆଗରେ ଏଇ ବୟାନ ଦେଉଅଛି କି ଗତ 5/9/2019 ସକାଳ ପାଖାପାଖି 9ଟା ହେବ, ମୁଁ ଆମ ଗାଁର କିଛି ପିଲାମାନେ ମିଶି ଆମ ପଡାରେ ଭୋଜି କରିଥିଲୁ। ଭୋଜି ସରିଗଲା ପରେ ମୁଁ ଆମ ପଡା ଛକରେ ବସିଥିଲି। କିଛି ସମୟ ପରେ ମୋ ଭଣଜା ପୀତାମ୍ବର ଦନସେନା ସେଟାକୁ ଆସିଲା। ଆମେ 2 ଜଣ କଥାବାର୍ତ୍ତା ହେଉଥିବା ସମୟରେ ଆମ ପଡାର ସୁନାଧର ନାଗ ମତେ ଡାକିଲେ ଓ ମୋ ଗାଡିରେ ତାଙ୍କ ସମୁଦି ଶ୍ରୀଧର କରୁଆ ଡିସିଜ ନେଇ ତାଙ୍କ ଗାଁ ଖଲିଆ ସାହିରେ ଛାଡି ଦେବାକୁ କହିଲେ।
କିଏ ଗଲ?
ସୁନାଧର ନାଗ ଟୋଲ୍ଡ ଦ୍ୟାଟ ଶ୍ରୀଧର କରୁଆକୁ ନେଇ ତାଙ୍କ ଗାଁରେ ଛାଡିବା ପାଇଁ। ତାପରେ ମୁଁ ମୋ ଭଣଜା ସୁନାଧର ନାଗ
ତାହେଲେ ତାର ଆଉ ଡିସିଜ ର ଗଲେ,
ସେ 2 ଜଣ ଆଉ ଡିସିଜ ଗଲେ।
ହଁ 2 ଜଣ କିଏ?
ନୀଳାମ୍ବର କରୁଆ ଆଉ ସେ ଯୋଉ ପୀତାମ୍ବର ଦଣ୍ଡସେନା ତା ଭଣଜା। 2 ଜଣ ଡିସିଜ କୁ ନେଇକି ମୋଟର ସାଇକେଲ ରେ ଗଲେ। ତାପରେ ମୁଁ ମୋ ଭଣଜା ଶ୍ରୀଧର କରୁଆଙ୍କୁ ମୋ ମୋଟର ସାଇକେଲ ବସାଇ ଖଲିଆପାଲି ଛାଡିବା ପାଇଁ ବାହାରିଲୁ। ମୋ ଭଣଜା ମୋଟର ସାଇକେଲ ଚଲାଉଥିଲା। ଶ୍ରୀଧର କରୁଆ ମଝିରେ ବସିଥିଲା ବେଳେ ମୁଁ ମୋଟର ସାଇକେଲ ପଛରେ ବସିଥିଲି। ଖଲିଆପାଲି ଗ୍ରାମରେ ପହଞ୍ଚିବା ପୂର୍ବରୁ ହଠାତ୍ 2 ଜଣ ରାସ୍ତା ଆଗକୁ ଆସି ଆମ ମୋଟର ସାଇକେଲକୁ ଅଟକାଇଲେ। ସେମାନେ ମୋତେ ଓ ମୋ ଭଣଜାକୁ ଶ୍ରୀଧର କରୁଆଙ୍କୁ ଛାଡି ସେଠାରୁ ଚାଲିଯିବାକୁ କହିଲେ, ନହେଲେ ସେମାନେ ଆମକୁ ପିଟିବେ ବୋଲି ଧମକ ଦେଲେ। ଏହି ସମୟରେ ଖଲିଆପାଲି ଗ୍ରାମର ଅମର ତହସିଲ କରୁଆ ଗ୍ରାଣ୍ଟେଡ ବେଲ୍ ଓ ତାଙ୍କର ପୁଅ ଆମ ଆଡକୁ ଧାଇଁ ଆସିଲେ। ସେମାନେ ସମସ୍ତେ ଏକାଠି ହୋଇଯିବାରୁ ମୁଁ ଓ ଭଣଜା ମୋ ମୋଟର ସାଇକେଲରେ ଆମ ଗାଁକୁ ଫେରି ଆସିଲୁ। ପରେ ଗାଁରୁ ଫେରି ଜାଣିବାକୁ ପାଇଲୁ ଯେ ସେଇ 5 ଜଣ ଲୋକ ଶ୍ରୀଧର
ଯୋଉମାନେ ବେଲରେ ଯାଇଛନ୍ତି, ସେ ଯୋଉ 2 ଜଣ,
they have been named.
They have also been named to be present at that spot.
Yes, ma'am.
That is also last seen is against them.
Yes, ma'am.
Yes.
ଆଉ ସେ ଯୋଉ weapon of offense ଟା ଯୋଉ ସିଜ୍ ହେଇଥିଲା ଯୋଉ 27 ରେ PW1 ଗଦାଧର କରୁଆ he turned hostile and the
What is their case number and what is your case number? Your case number is 61 of 23.
yes my lord, and their case number is
SC number 6 of 2020. Acha.
yes SC number page 17.
Take down. This is BLAPL number. And they have been charge sheeted under section 341, 302 by 34 of the Indian Penal Code. The occurrence in question took place on 5/9/2019, and there is no direct evidence in this case. And the circumstantial evidence is that of extrajudicial confession as well as last seen of the deceased in the company of the accused persons. Learned counsel further submits that witness to the extrajudicial confession namely ତା ନା କଣ ଅମର ସିଂ କରୁଆ
ବିଶ୍ୱନାଥ କରୁଆ
ଆଚ୍ଛା
ସବି
ବିଶ୍ୱନାଥ କରୁଆ being examined as PW2 in the connected sessions case number 6 of 2020 has not supported the prosecution case for which he was declared hostile. And two of the co-accused persons, namely Tahsil Karua and Amar Singh Karua, have already been released on bail. And though, as per the statement of Nilambar Karua and Pitambar Dandasena, the deceased was last seen in the company of the accused persons, including the petitioners. But same material is also there against the co-accused persons, Tahsil Karua and Amar Singh Karua, who have already been released on bail. And therefore, the bail application may be favorably considered. Learned counsel for the state, after verification of the case record, fairly submits that the petitioner is similarly situated like the two co-accused persons who have been granted bail. However, he submitted that the petitioner was an absconder for about 4 years. Petitioners, considering the submission made by the learned counsel for the respective parties, the nature of accusation against the petitioner, since the absence of any direct evidence, since the co-accused persons similarly situated have already been released on bail. The bail order copies of the co-accused persons have been annexed to the bail application as Annexure 3 series. I am inclined to release the petitioner on bail. It will appear before the London trial court on his dent, shall not try to tamper with the evidence, shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail. Allowed.
Item 39.
May I please, Your Lordship? CD record, my lord. Press case.
Press case?
Yes, miss.
What is the offense?
376, Your Lordship, 376, 376, 3.
3 to notice you.
Yes, Your Lordship. 376 2N, 373 506 and 6.
3 achi to?
Yes, Your Honor.
Acha, extra copy to be served. Notice to be issued. CDCA confirmation letter. Yes.
Item 40.
May I please? Sir, in this
Press
matter, the petitioners has
What is the offense?
302.
302 is similar situated persons who has been granted bail by this honorable court on 5th April and 21st
See, the number case diary thai pare.
7 persons out of
It's all right. Just he is to verify whether you are the learned counsel for the petitioner submits that similarly situated co-accused persons have already been granted bail, and he has furnished the bail order copies to the learned counsel for the state. Learned counsel for the state submits that he will verify whether the case diary is available in the AG office or not, and also the claim of parity. Put up this matter in the week commencing from 22nd of April 2024.
Item 41.
Your Lordship, in item 41, I am appearing virtually, Your Lordship.
Yes.
Lordship, this is a bail matter. In this case, Your Lordship, the allegation is that the petitioner and her husband committed murder of one Golek Chandra Behera in whose house they were.
Belgium matter. Why I think bail matter? The
Belgium matter.
Yes, Your Lordship.
So arrested on the strength of NB on so charge as framed. ଆଗରୁ ବେଲ୍ ଥିଲା ବୋଲି କୋଉଠି ଲେଖା ହେଇଛି?
Lordship, at Annexure 3, this court had allowed.
3.
Yes, Your Lordship.
Okay. Heard the learned counsel for the petition, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner was on bail and due to non-taking of steps on the date fixed, non-bailable warrant of arrest was issued against him, for which she was taken into judicial custody on 27/2/2024. बाकी बेल्जियम की रिकवरी ना अलाउ कर दे.
Item 42.
Obliged, Your Lordship.
Mr. Biswajit Mahapatra. Yes.
This is also Belgium.
Belgium matter.
Yes.
Petitioner was on bail.
NBW issued on 2/2023 and arrested on 9/2/2024. It is 20B2B NDPS.
9/2/24 ରୁ ଭିତରେ ରହିଛି. ଆଗର ବେଲ୍ ଅର୍ଡରଟା କୋଉଟା?
Bail order ଅଛି 7/9/2017. Page number 13. Under Annex 2.
Page number 13 ରେ.
The accused petitioner.
अच्छा. देखो. The petitioner submits that the petitioner was on bail and due to non-taking of steps, non-bailable warrant of arrest was issued against him, by virtue of which he was taken into judicial custody on 9/2/24.
24.
हाँ. बाकी सब करके allow कर देवे.
Item 43.
Item number 43.
May I please, madam? The appellant filed PC miscase for a
45.
Please, your lordship.
On the basis of the prisoner's petition at flag C, Mr. Pramod Chandra Sejpura has filed the Vinama. Vinama is accepted. His name shall be accepted. Yes.
Please, your lordship. Lordship, 1 week time may kindly be granted to file the surrender certificate.
Whether he has surrendered or not.
Yes, surrender.
All right. Learned counsel for the appellant submits that she has received instruction that after availing the interim bail period, the appellant has surrendered and she may be given some further more time to file the surrender certificate of this matter in the week commencing from 29th April 2024. Surrender certificate shall be filed in the meantime. Yes.
Okay.
Item number 46.
May you please, lordship.
3/2024, the petitioner was released for 1 month, though he has suffered, he has undergone 6 years, 6 months, 6 days on the date of consideration of his bail
No,
application.
now
He has to, sir, he has already surrendered. I have only soft copy. I praise only 2 days time to submit that.
okay, Mr. Mishra and counsel appearing for the appellant submits that he has received instruction
On
that
6/4, before 1 day he has surrendered.
appellant has already surrendered in the trial court and he may be given some time to produce the surrender certificate. Put up this matter in the week commencing from
Monday. Maybe Monday. His wife is ill.
No, you have not filed any other
I have to
application.
file along with that.
File that application and make a mention. Put up this matter in the week commencing from 22nd April 2024. This application, another application is pending, stay realization of fines allowed.
May I pray? Week commencing 15.
अरे आपण surrender certificate file करिवे
Tomorrow I am going to file.
File करंतु bail application file करंतु make a mention.
Okay.
मना करछि ना. Yes.
Now 49.
May I please, ma'am? Petitioner is convicted under section 20B NDPS Act. Out of 10 years, petitioner is
Sentence
8 years.
imposed is 10 years.
Yes, ma'am. 8 years. He is in custody since 24/10/2016.
Custody certificate ଅଛି.
No.
10 ବର୍ଷରୁ କେବେଠୁ ରହିଲେଣି କହୁଛନ୍ତି
24/10/2016.
ରେକର୍ଡଟା ବାହାର କଲି ଫାଇନାଲ ଫର୍ମ ପାଇଁ କଣ ନାଁଟା କଣ ମୋହାମ୍ମଦ ସୋନୁ ହଁ ମୋହାମ୍ମଦ ସୋନୁ ଫରୱାର୍ଡିଂ ଡେଟ୍ ହଉଛି 25/2/2017 ଆଉ ତା ଭିତରେ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ୍ ଯାଇଛନ୍ତି ନା ନାଇଁ
ନା ଯାଇନି
25/2/2017 ପଳେଇ ଆସିବ Sonu produced in custody. Sonu produced in custody. Okay. Sonu produced in custody. Sonu produced in custody. Sonu produced in custody. Yes. Yes. It's main application operation. Yes, Mr. Tripathi, she is right. 25/2/2017 ରୁ ଭିତରେ ଅଛନ୍ତି
Yes, that is true, but he also is from Bhagalpur, Bihar.
ଆଚ୍ଛା ଆପଣ ନେଇନାହାନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇନାହାନ୍ତି ତ ହେଲେ ତାଙ୍କର ପାଖାପାଖି 7 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଇଯାଉଛି Alright, you furnish the names, address and of 2 local sureties and he will ascertain your the correctness of the address.
Yes.
Lekhandu, the Learned Council IN number 43 of 2024. This is an application for bail. The Learned Council appearing the petitioner Mohammad Sonu submitted that the petitioner is in judicial custody since 25/2/2017 and thus out of 10 years of substantive sentence imposed by the Learned Trial Court, he has already undergone more than 7 years of sentence. Learned Counsel for the state, on the other hand, submitted that the petitioner is a man from district Bhagalpur in the state of Bihar and he may be given some time to verify whether the address furnished in the cause title is correct or not. Land counsel for the appellant petitioner shall furnish the names, address, and documents of two local sureties who are interested to take the petitioner on bail. On receipt of the same, instructions shall be taken by the land and counsel for the state through IIC of Gunpur police station. Put up this matter. केबे देबे आपण दीटा लोकल सिक्योरिटी को आपण दबार पड़ियो तो बाकी तापर से आनिबे एड्रेस आपनकर ठीक अछि ना नाही सप्ताह भीतर देई परिबे हां ऑल राइट put up this matter in the week commencing from 6th of May 2024 all right
Item 50.
हाँ
Stay relation fine आइए
फाइन दिया ही नहीं, स्टे दिया ही नहीं,
हाँ previous council ଦେଇଛନ୍ତି
स्टे फाइन ଆପଣଙ୍କର
ଫାଇଲ ହେଇଛି କି ନାହିଁ ମୁଁ ତ ସେଟା
आईए नंबर तो इंटरिम एप्लिकेशन आपण फाइल करनांती
ନାଇଁ ସେ previous council ଏଟା engagement ଥିଲା ତ
ହେଲା ଯେ ଆପଣ जो सबमिशन ଟା कले ना जे स्टे रियलाइजेशन
ବେଲ୍
ऑफ
ପାଇଁ
फाइन
ଥିଲା stay ପାଇଁ ଏଟା
हां
ବେଲ୍ ପାଇଁ ଥିଲା କି stay ପାଇଁ ଏଟା
स्टे ପାଇଁ कोन आपण फाइन करनांती मु आपण दान करबी ना कोन
ମାନେ ଏଟା
यस नेक्स्ट
Item 53.
May I please, Your Lordship? Lord, here this appellant convicted under section 304 part 2, my lord, and sentenced him to undergo RI for 10 years and fine of rupees 10,000, my lord. And this petition is at about 80 years and custody is about 6 years, my lord. More than 6 years, my lord. And that is evident from page 2 of the judgment.
your
running page
bail application was never rejected on merit.
This is first time, my lord.
First time,
My lord.
so sentence is 10 years.
10 years, my lord.
And you are not on bail during trial.
The trial court has stated 2,148 days in custody, my lord. Your lordship, page 13, running page 13, judgment page 2, your lordship. Accused status.
तो केते दिन होची आपनकर
4 वर्ष 8 मास होची एबटे 5 मास ही 5 वर्ष 8 मास होची एबटे 5 मास 6 वर्ष 2 मास होय
more than 6 years, Mr.
More than 6 years.
Are the land and counsel for the petitioner and counsel for the state single appellant here?
Single appellant.
Considering the submission made by the land counsel for the petitioner that the sentence imposed on the petitioner is for 10 years and he has already undergone more than 6 years of sentence and there is no chance of early hearing of the appeal, and after going through the impugned judgment and hearing the land and counsel for the state, I am inclined to release the petitioner on bail, stay realization of fine.
Oblige.
Item 54. Item 55.
May I please, my lord? The appellant was
Mr. Patro,
That is not OPID matter. it is
my lord.
अच्छा OPID ଲେଖା ହେଇଛି
Yes, sir.
ଲେଖା ହେଇଛି
OPID
OPID
court
court କରିଛି but conviction ହେଇଛି
ସେ IPC ରେ,
IPC
no is he not, you are not facing trial under OPID?
No, my lord. Charge under section IPC offences.
अच्छा
But the
Oh,
investigating officer is EOW OPID.
if it is OPID act ଥିଲେ ବି ସେମାନେ
4/6 price treated for the night.
but there is no okay
Charge
but,
nahi conviction.
right. So now
Now maximum sentence is 7 years, my lord.
just a minute. So what is the operative part of the
page 40, 52, running page 52, page 40 of the trial court judgment.
52 होची running page?
My lord. Direct the convicts to undergo RI for 5 years and to pay fine of rupees 50,000 only each, and in default of payment of fine to further undergo RI for a period of 6 months each for the offence under section 420 IPC. To undergo
7 years ହେଇଛି 467 ପାଇଁ.
My lord, 467.
Concurrent sentence. Concurrently, huh?
My lord.
So 7 years ରୁ ଆପଣ କଣ କେତେ?
My lord, during trial I was on bail 11 months 16 days. After conviction near about 1 year 6 months. Date of judgment is 15/12/2023. Page 15 of the trial court judgment. serial number 2.
27/3/2022 ରୁ 13/3 ମାନେ ପ୍ରାୟ
11 months 16 days.
ଏଇ
ଆଉ
ବର୍ଷେ
ଏବେ
ତାପରେ
4 months
ସେଣ୍ଟେନ୍ସ କିଏ ହେଲା ଜଜମେଣ୍ଟ କେବେ ହେଲା 15/12
15/12/23.
Or the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the petitioner submit that the
I beg
petition.
your pardon, my lord. In this case, he was on bail during trial.
After 13/3/2023
In
ପରେ
that
bail
case, the Honorable High Court has directed him to pay 10 lakhs rupee deposit. He has deposited only 6 lakhs.
କୋଉଠି
ତଳ କୋର୍ଟରେ
ତଳ court. ତାପରେ conviction ହେଇଯାଇଛି, he has not paid.
এটা modify
ବାକି ଯାହା ଥିବ ତ ସିଏ ତାଙ୍କୁ ଦେଇ ସାରିବେଣି ଆଉ ନ ଦେବେ the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the petitioner submit that the petitioner was taken into custody on 27/3/2022 and he was released on bail on 13/3/2023 and after conviction on 15/12/2023 he has been released on bail. He has been taken into judicial custody and there is no chance of early hearing of the appeal in the near future and balance of convenience is in his favor and therefore the bail application may be favorably considered. Learned counsel for the state submitted that while granting bail during trial, this court imposed a condition of deposit of cash security of rupees 10 lakhs and the petitioner has deposited cash of rupees 6 lakhs. Considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, sentence imposed by the learning trial period already undergone by the petitioner, fact that he was on bail during trial and there is no material that he has misutilized his liberty, absence of any chance of early hearing, I'm inclined to release the petitioner on bail, stay realization of fine.
Obliged.
A copy has been served by them, so like
ଅଫିସ କେବେ ଯୋଉଟା 12 lakhs ଟା ହେଇଛି 6 lakhs deposit ହେଇଛି.
bail order copy ଟାକୁ ଦେଲେ ବୋଲି ଲେଖିଦେବେ. It was granted by bail and he files the copy of the bail order which is taken on bail.
Sure. Obliged.
Yeah.
Please.
Item 63.
At 63, may I please?
Yeah.
Let's before coming to the facts of the case, I filed an IA, that is IA number 666.
Right. IA number 666 of 2024 is an application for change of nomenclature from CRLA to CRL REB. Stamp reporter से देखी
आगे.
The stamp reporter has also pointed out that the case is to be registered as CRL REB. In view, Land Council for the state has no objection. Accordingly, the CRLA prayer made in the interim application is allowed. The CRLA be re-registered as CRL REB and be placed before the assigned bench. Yes.
Obliged.
My lord, may I please? My lord, may I please from Bhavani Patna Virtual Court, my lord?
Please wait. Okay, here is also same nomenclature to be changed, and it is to be re-registered as CRL REB and be placed before the assigned bench. Hard Mr. S.S. Singhdev, Land Council, appearing through virtual High Court, Kalahandi at Bhavani Patna. Yes.
Item 65.
Item 65, my lords, although I have filed an application for condonation delay, but as
delay in filing the criminal appeal.
And so far as the
Land Council for the appellant seeks permission to withdraw this application. Accordingly, IA is disposed of as withdrawn.
my lords,
main
application.
My lord, delay 60 days delay. Appellant is convicted under section 20B2C of NDPS Act 10 years.
Sentence.
10 years, my lord.
10 years.
10 years. Delay condone. Admit. Accusal order. Yes, next.
Item 67.
10 years, my lord. 62 days delay.
69 days delay. So delay
69.
condone. Admit. Usual order. Next. ଦେଖିଦେବେ interim application for bail ଭଳିଆ ସବୁଥିରେ ଫାଇଲ କରୁନାହାନ୍ତି ତ ଯୋଉଥିରେ ଥିବ ସେଗୁଡା Mr. Bahadur
Dictation को पूरा दो.
କୋଉଥିରେ
Today I'm filing court.
କୋଉ matter
Sir, say 67 टा.
67 a deposition copy served in court for them. Yes, next.
Obliged, sir.
Item 68.
Yes,
Lordship,
what is it?
on behalf of Mr. Bahadur, my lordship, there is a 92-day delay.
Okay, delay condone. Conviction matter.
Yes, my lordship.
What is the sentence?
20 years rigorous.
All right.
Item 69.
Let convicted under section 376(1) of IPC, sentenced to undergo RI for 12 years and a fine of rupees 20,000.
Delay कौन था?
Delay 18 days delay.
All right. IA number so and so. Delay condone. Admit. Back usual order. You have filed interim application for bail.
Yes, my lord. Yes.
Okay. Next.
Item 70.
My lord, in item 70, the matter arises out of order under section 457 of CRPC.
Since
No, what is the delay?
delay of 96 days, my lord.
No, it is 37 days.
37. Okay. You paid.
What?
As per the Council of the OPID balance is pass over, my lord. 70 items.
No. Ask Mr. Patra. It will be listed next week.
Another matter was continuing before in other court, my lord. That's all.
Are ତାଙ୍କୁ ଏଇଟା ମୁଁ ଆଣିବି next week ରେ ଆଣୁ
My
ତାଙ୍କୁ
lord.
ଦେଇଦେବି।
My lord.
The Learned Council for the state has pointed out that the matter arises out of an order passed by the presiding officer designated court under the OPID Act Cutter, and wrongly copy has been served on her, and she will hand over the copy of the appeal memo to the Learned to either Mr. Vivekanand Bhuiya or Mr. J.P. Patra, the Learned Special Counsel, who is to appear for the state of Orissa in such matters. Put up this matter next week. The names of Mr. Vivekanand Bhuiya and Mr. J.P. Patra shall be reflected in the cause list. Hello? Yes. $71, Mr. Chinchani.
This is an appeal under section 370.
370?
Filed by the victim.
Yes. What order was passed by the Learned Trial Court?
Trial court acquitted the accused persons by having a certain perverse conclusion.
So what is the offense here?
Offense under section 147, 148, 455, 436, 380.
Who is appearing for the other side?
On behalf of Ganlok Mahanti, sir, his father passed away.
Hmm.
On behalf of Mr. Ganlok Mahanti, his father passed away and first.
Okay. A mention is made on behalf of the Learned Council for the respondent that there is bereavement in the family. Put up this matter in the week commencing from 29th of April 2024. Yes.
Can it be admitted like
No.
because LCR may be required.
Maybe. Yeah.
Because
I may not admit it, may dismiss it. So
no,
yes,
but,
next.
Wait,
The Learned Council is seeking for time and the reason you know. Yes, next case.
Item 72.
Yes, Mr. Rothon.
Please, Lordship.
What is this matter, CRLA for?
Challenging the order of cognizance under section 6 of the OPID Act.
So, cognizance order is under challenge.
Yes, ma'am.
So,
This case has a checkered history, my lord.
No. Which order you are challenging?
Order under Annex
Page 70.
1, my lord. Page 70.
17.
17. 11 order data 11/11/21.
So, what the Learned Trial Court has done in this order, he has taken cognizance of the offences.
Yes, my lord.
So, what happened, my lord? Charge sheet filed without section C OPID Act, my lord.
May sir, sir call it.
No, that we are not on that. This order was passed on 11/11/21.
My lord.
So, in the meantime, more than 2 years and 2.5 years have passed.
Yes.
So, what is the present position? Because no stay has been granted.
Right. Charge is yet to be framed. My lord is on the last occasion.
Last occasion? What last occasion?
Record the status report may be called for from the OPID Act.
Status report
at flag C पर लिखा है.
It has been called for. Yes, it is there.
In obedience to so and so, cognizance offense was taken on 11/11/21, and IO submitted the final charge sheet against the accused persons under so and so, and counsel for the so and so has taken appearance for some. Oh, the date is fixed for appearance of the accused. That means it has not.
Initially, my lord,
Okay. On what ground you are seeking? Where is your note? On what ground you are seeking to quash the order of framing charge?
Yes,
Yes.
Before I submit, I just 1 minute for facts. Now, this affair was lost in the 10/5/2013. Affair lost in 10th of May 2013. That's prior to coming into force of OPID Act. Cognizance was taken on 12/7/2013. Again, prior to coming in force of OPID Act. Now the trial has commenced. Trial has concluded, in fact. 14 witnesses in the total charge sheeted witness, including the 2 IO. 13 of them have examined. Informant and first IO. Second IO was to examine. That's total 13 men. At that stage, the trial court discovered that cognizance under section 6 ought to have been taken. Under 6 of the OPID Act.
But what is this report which has come from the presiding officer? So he has sent it to the court for, all right.
So I have annexed all the evidences and everything. Now, on 30th 10/2021, now the trial is almost complete. The second,
no, that was pending before one court. That was pending in CGM court.
Yes, madam.
Now it has been transferred to the designated court because he found that the offense under section 6 of the OPID Act is there.
Yes. There is no charge sheet under section 6.
Maybe charge sheet.
Maybe I agree, madam.
Yes.
But and at this stage, he has sent it. He now takes the cognizance.
He is not. It is not that he has no power to come to a finding that if some other offenses are made out and which he is not competent to try, then he has to send the records to the higher court for trial.
That's correct, madam.
Which is that provision?
That is 325.
No. 323.
323, madam. The procedure when, after commencement of inquiry and trial, the magistrate found that the case should be committed. In case of an inquiry or trial before the magistrate, it appears to him at any stage of the proceeding before signing of the judgment that the case is one which ought to have been tried by the court of session. He shall commit it to that court under the provisions and after.
No, another 322 is also there.
Yes, my lord. Procedure in case when magistrate, a case in which magistrate cannot dispose of.
If in the course of an inquiry into the offence or trial before the magistrate, in any district, the evidence appears to him to warrant a presumption that he has no jurisdiction to try the case. Here is like this. So once it is 6 OPID Act, he has no jurisdiction. That is how he has exercised this, though the CGM has sent it. So he has jurisdiction. So question is that whether the offense under section 6 of the OPID Act in the evidence adduced so far before the magistrate is made out or not. So what is that 6 OPID Act?
6 OPID Act.
বই খোঁজিলে হব কি এটি
বইটা সেটা
বই খোঁজিবে সে মোবাইল খোঁজিলে সেটা କେମିତି ହବ ଏଠି ଆପଣ ବି ଆଣିନାହାନ୍ତି ଘରେ ରଖିଦେଇ ଆସ ଆର୍ଗୁମେଣ୍ଟ କରିବେ put of this matter on 16th of April 2020. Yes. Next.
Item 73.
Yes, 73.
The matter of NDPS, the recovery of the vehicle, release of vehicle, your lordship last occasion direction to the State Council, take instruction, madam.
What instruction? What is this matter for? What is your prayer in this appeal?
Lordship would Release of vehicle, my lord, it is a condition confirming. Your lordship, go to page 20 of the order part.
So you are an accused in the trial court.
Yes, my lord. But this person is not accused. He is a vehicle, owner of the vehicle, my lord.
Partially whether this Vishnu Priya Sahu
No, he is not accused, my lord.
was not an accused. So two persons, as it appears,
Yes,
face trial. They are Dilip Kumar Behra and Jitendra Behra.
my lord.
Now the offense is under 20B2C.
My lord.
Okay.
My lord.
So what is the finding of the London trial court that miserably failed to assert? They have been acquitted.
Yes, my
Then so far as the vehicle is concerned,
yes, ma'am.
the line is that so far as the disposal of the seized vehicle in question,
Yes, ma'am.
white color Scorpio so and so, considering the aforesaid facts so and so, the vehicle in question being used as a conveyance is liable for confiscation and so on. So hence the seized vehicle be confiscated accordingly after observing due procedure provided so on. So yes.
So your lordship asking to whether it is confession or not.
This order was passed on 15th. So what happened now? What is the status of the vehicle now? Consider.
Instruction manual ticketing.
Now confiscation proceeding out to इसे तो direct कही दिला confiscated to the state or confiscation proceeding तो initiate ही नहीं totally.
Lordship, actually one thing. Lordship direction to the for confiscation proceeding.
No. You have to satisfy that what is the NDPS Act? Mrs. Sahu, you come to the section 63, the proviso to subsection 2 of section 63. 63 deals with procedure in making confiscation. And you read subsection 2.
Where any article or thing seized under this act appears to be liable to confiscation under section 60, section 61 or section 62, but the person who committed the offense in connection therewith is not known or cannot be found, the court may inquire into and decide such liability and may order confiscation accordingly.
ତାପରେ ପଢନ୍ତୁ.
Provided that no order of confiscation or an article or thing
Confiscation of an article
my lord,
or thing
my lord,
shall be made
until
until expiry of 1 month from the date of seizure without hearing any person
my lord,
who may claim any right thereto and the evidence, if any,
my lord,
which he produces in respect of his claim. Okay,
My
then the opportunity is to be given, and if the owner, you come to section 60, subsection 3.
my lord.
Read it out. Section 60, subsection 3.
Any animal or conveyance used in carrying any narcotic drug or psychotic substances or any applicable to confiscation under subsection 1 or subsection 2 shall be liable to confiscation unless
This is most important. Unless
the owner of the animal or conveyance proves that it was so used without the knowledge or connivance of connivance of the owner himself, his agent, if any, and the person in charge or of the animal or connivance, and that each of them had taken all reasonable precaution against such use.
तामाने दीटा जिनस हला जे
Right.
कन्फिस्केशन आपण करि परिबे नाही without giving an opportunity of the hearing to the person who might claim any right thereto. तापरे vehicle केतेबेले रिलीज हबो ओनर फेवर रे ना जेतेबेले से कोर्ट रो satisfaction को आनी पारिबो जे without his knowledge or without his connivance the vehicle has been used and he had taken all reasonable precautions against such use. ताकू ड्राइवर को कहतला बाबू ये सब करिवनी हम करिवनी ये सब करिवो एवं मोर तार टोटल ज्ञान नाही सीए देइथिला आकू नेकिन जीवा को अन्य कामरे तार ड्राइवर तार सो मोटो माने व्यवहार करची ताकू यूज करिवा को ट्रांसपोर्ट करिया को ये vehicle ये जिंस जदी कोर्ट सैटिस्फाई हबो ताले कन्फिस्केशन हबो नै ओनर फेवर रे जा तेणु कन्फिस्केशन vehicle करिवा पूर्वरु ओनर को अपॉर्चुनिटी दबा मैंडेटरी ताकू अपॉर्चुनिटी दबो सुनानी करिवो सी हुए तो एविडेंस मध्ये एड्यूस करि पारे जोटा कि सबसेक्शन 2 रे रहउची सेक्शन 63 रे हला तेणु एगुडा को किछि न करी जजमेंट रे तांकू एक्यूटल कर दला एवं स्ट्रेट अवे विक्टिम जो vehicle को कन्फिस्केट कर दला ओनर को कोनोसी की अपॉर्चुनिटी दिया गला नाही तेणु एठी ये जो प्रोविजन अच्छी सेक्शन 60 और coupled with section 63 that has been flouted in this case. So where is the decision?
Sorry, I'm not ready.
Where in this case there are decisions on this respect that unless this is mandatory provision, the owner has to be given notice and has to be given opportunity of hearing, and only if the trial court comes to a finding that this is not in connivance or in knowledge, then can only be there. So find out the decision. Okay. The learned counsel for the state has produced written instruction received from officer in charge of excise mobile Kandhamal to the effect that during pendency of the investigation, he had issued summons to the owner of the vehicle, but no one appeared before him. And so far as confiscation proceeding is concerned, no such proceeding has been initiated. Learned counsel for the appellant seeks some time to examine the case laws as to whether, without the compliance of section 60 and 63 of the NDPS Act, the vehicle can be confiscated to state. The seized vehicle under NDPS Act can be confiscated to state, as has been done by the London trial court while acquitting the accused persons. Yes. Put up this matter in the week commencing from 22nd April 2024. Yes.
In this, the petitioner is challenging the order of dated 12/9/2023 passed by the London Court presiding officer designated code OPID.
What order has been passed?
12/9/2023.
No. What is your petition and what order has been passed? Kon prayer thila?
The prayer was to release of money, and in this the.
So it's a OPID Act matter.
Yes, ma'am.
So
No, my lord, it is not OPID matter.
Yes.
The order of OPID, but it is not the UW matter, my lord.
UW matter.
My lord, regarding that instruction.
There is no OPID Act case in this. All right. So you filed a petition for release of the cash.
Yes.
In your favor. That has been really rejected.
Yes, my lord. The accused has been arrested.
All right. You take instruction in this matter and get from the. Have you received the instruction?
Regarding item 74 instruction, which regarding 75 instruction yet to receive.
Similar.
No, 70.
Similar matter.
instruction ନେଇଛନ୍ତି ସେ ଏକା ଜିନିଷ
It is the matter of 74.
75 also, my lord, similar matter.
no similar matter ଯେ ସେ instruction ନେଇଛନ୍ତି item number 70
74, 75, same. Same matter, my lord. IU was present.
अच्छा arises out of same case.
My lord.
Okay, then it's all right. During investigation, it is ascertained that the total number of amount of rupees 1,48,575,
Yes, ma'am.
which was credited to the account number so and so, being transferred by the petitioner is maintained in the name of Jagadamba Enterprises, maintained with Yes Bank, Patiala, Punjab, and Rajat Singh is the proprietor of the said farm. So and so. During investigation, the statement of the account so and so. It is established that the money transferred by the petitioner is lying in the account of Jagadamba Enterprises. The petitioner does not have entitlement so and so.
I'm sorry, no, less, Mr.
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ ତାକୁ ଏ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଟିକେ ଦିଅନ୍ତୁ ସେ ପଢନ୍ତୁ ସେ କଣ ସେ କହିବ କାହିଁକି ହେଲା ତାକୁ ଗୋଟେ କପିଟେ କରି ଦେଇ ଦିଅନ୍ତୁ ଆଜି ହଁ so we'll take up this matter next week give a copy learn and council ଆର କପି ଅଛି ତ ଆପଣଙ୍କ ପାଖରେ and the IO is present you are the IO all right Swarnalata Panigrai inspector and IO of the case EOW Bhubaneswar is present she has filed the written instruction which is taken on record. Let a copy of the written instruction be served on the Land and Council for the appellant. By tomorrow, like Doji, Mr. Sahu, put up this matter in the କେବେ ଆସିପାରିବେ ଆପଣ କଣ ଦରକାର ହବ ଏବେ କେବେ କୁହନ୍ତୁ ଗୋଟେ ମଙ୍ଗଳବାରିଆ ନେଇ ଆସିବେ
Next week, any date.
ଆଚ୍ଛା all right so let it come on 16th all right put up this matter on 16th April 2024 along with CRLA number 1314 of 23. You go through the written instruction, huh? It out taken on record for them. How did you pass over?